Hello, I'm David Roger, General Counsel for the Las Vegas Police Protective Association. In this segment, I want to talk to you a little bit about bail reform and a Nevada Supreme Court case that imposed certain requirements that judges have to follow, as well as an amendment to the statute which took place in 2021. And so first, I understand the scenario. You make a probable cause arrest on an individual. You file your declaration of arrest. AB 424 now requires a judge to review a person's custody status within 48 hours. And so judges will be working weekends now in order to comply with the statute. So within 48 hours, 2 days, a defendant is brought before a judge to review their custody status. In 2020, the Nevada Supreme Court took it upon themselves as a matter of constitutional significance to impose certain requirements as part of their decision to impose bail reform conditions. The Nevada legislature in 2021 codified the Nevada Supreme Court's decision. And so here is the case was Valdez versus District Court. And so here is the change to the statute. And, take a look at this statute when you get a chance. This is NRS 178.485. Except as otherwise provided in subsection 4, the court shall only impose bail or a condition of release, or both, on a person as it deems to be the least restrictive means necessary to protect the safety of the community or to ensure the person will appear at all times and places ordered by the court. And so this is mandatory language. They shall release a person who has been arrested on charges unless they feel that certain conditions should be imposed, and those conditions must be the least restrictive conditions necessary to protect the community or to make sure that the person shows up in court. And if a prosecutor requests that the court impose bail conditions or hold the person without or with cash bail, it is the prosecution's burden to prove by clear and convincing evidence that some type of bail is necessary to protect the community or to make sure that the person shows up in court. So to summarize, within 48 hours, a judge has to hold a hearing. They can only impose bail or other restrictions if there is clear and convincing evidence that it is necessary to impose such restrictions or require a cash bail to either protect the community or to make sure that the person shows up in court. So obviously this is a drastic change in bail from pre-2020 or pre-Valdez versus District Court. And so when you see these individuals being released after you have arrested them, understand the process. The process is one, as we know from a previous video, the prosecution must file a complaint forthwith, and so that means that you have to get your reports in, and they have to make it over to the DA's office, and the DA's have to file a complaint forthwith if they're going to prosecute the case. And then secondly, within 2 days or 48 hours of the person's arrest, a judge has to review their bail status, and the judge has to release them unless there's clear and convincing evidence that the person is a danger to the community or there's a likelihood that the person will not show up in court. And under those circumstances, a judge can only impose the least restrictive requirements to make sure that the person makes it into court. Obviously, it makes our job a lot more difficult, but it's important for you to understand the statute and the law when you see these individuals being released, and know that there are laws and requirements in place that sometimes tie the hands of judges. I'm not saying that's always the case, and as I've said before, I'm all for holding judges and prosecutors and the district attorney and the department accountable, but there are certain restrictions on what everybody can do. I hope this answers your questions. If you have any issues, please contact me at droger@lvppa.com. Thank you.
111, 110.